I want to talk to you today about an evidentiary rule in sexual assault cases. It's called narrative, and I'll give you an example and then explain it. So let's say, for example, that a complainant, a victim, is sexually assaulted, they're raped, the accused leaves the building where they are, or their bedroom. They then, the next day, go and tell their boyfriend that they were sexually assaulted, or even that night. And then they tell their friend that as well, and then they go to the police, okay? And in their statement to the police, they gave all sorts of detail about what they're told their bedroom. Now in court, the Crown would be able to lead a little bit of this limited narrative. And in other words, they'd be allowed to say, look, I told my boyfriend right away, I was emotionally distraught. I then told my friend the next day. Then I went to the police and told my version of events. But they're not allowed to get in the details of this. So what's the use of this evidence? It just shows the context of the development after the alleged sexual assault, how it came to the attention of the police, so the jury or judge can understand the unfolding of events of how it came to the attention of the police. But you see, the jury or a judge has to say to the jury, the fact that she repeated that she was raped doesn't mean she was raped. I mean, a judge will say to a jury, once a lie, always a lie, or once a truth, always truth. But you can't use it just because she told her boyfriend she was raped doesn't mean she was raped. It's only used for the limited purpose of how it came to the attention of the police, so we can understand the flow of events. So it's a difficult concept to grasp in a way for a jury, and we really have to bring it home. Judges know this intimately if it's a judge alone trial, but we have to bring it home intimately and explain to the jury. Look, just because a person cried rape doesn't mean she was raped. Maybe she was, maybe she wasn't. It's for a very limited use. There's another form of narrative where, which is another difficult concept, where a sexual assault victim will go immediately and be in terrible demeanor, in tears. Let's say it's a truthful victim, and say she was raped to someone. That evidence can be used in a less of a limited way. It may be consistent with credibility, so a judge could, and that's a very difficult concept. You have to dance around that. I won't get into all the details of that, but that goes a little bit beyond mere narrative. And yes, that can be used to maybe show she's consistent or credible with the allegation. So there's two uses of narrative. One is very limited. The other goes a little bit further towards a person's credibility, showing they might be credible or reliable. And because, let's face it, if someone's sexually assaulted, they may be in tears after. By the way, you might want to watch my rape myth and stereotype video tape. That's another whole different kettle of fish as well on the similar topic about what rape myths and stereotypes are. That's another video that I did that you'll find on my YouTube channel if you're a subscriber. So yes, I just want to, that's a wrap up on that particular topic. And I just want to mention that we have offices across the province. We're in Windsor, we're in London, we're in Kitchener, and we're in Toronto. And if you're charged with sexual assault or any type of crime, give our Toronto sexual assault lawyers a call, for example, and we'll help you and get the legal advice you need. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.